afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live this afternoon, as always, have the opportunity to ask questions and interact with our speakers. If you have a question, type it into the comments section below, and we will be sure to address it. Episodes are released each week following the live broadcast. So if you have anybody that you feel needs to see this episode, listen to this episode, or if you just didn't have a chance to show up live today, don't worry. Hit the subscribe button, click the alerts icon, and then you won't miss an episode. Today, we have Patricia Barasch and Richard Schall with us to talk about a successful employment case they recently tried using EDGE techniques. Now, employment cases are a wonderful place to use EDGE principles, but it's kind of a newer area. EDGE focuses or has traditionally focused a lot on a more personal injury area. So I am excited to have some employment lawyers on the show to tell us about these principles and how they worked for them. So Patricia and Richard, please tell us about your case.
All right, thanks, Jenna. We're very, very happy to be here sharing our experience and how the EDGE works in employment cases. So let me start just by kind of giving everybody an introduction about our case. It was a 2018 case, a single count age discrimination case in violation of the New Jersey Law Against Discrimination. We had a 2-week trial in New Jersey State Court, Mount Holly, Burlington County, New Jersey in late October 2022. Our client, the plaintiff, Terry Hall, had worked for Whole Foods for 20 years at the Marlton, New Jersey location from the time that store first opened. At the time of the termination, she was the team leader for the specialty department, and at age 62, she was the oldest team leader in the Marlton store, with the vast majority of the other team leaders being in their 20s and 30s. The jury returned its verdict for our client on a late Friday afternoon. The jury verdict awarded our client lost wages in the amount of $225,000, which was a little less than our expert report, and then also awarded her past emotional distress damages in the amount of $170,000, which was not on the basis of any medical testimony, but rather just on the testimony of her husband, whom she had been married to for about 40 years. The fun didn't stop there because despite several trial motions by defense counsel to strike or dismiss the punitive damages claim, they did so not during in their summary judgment brief, which we defeated, but for the first time they raised it on an in limine motion, tried to strike our punitive damages claim. They then renewed that motion once we rested, and then again at the conclusion of the defendant's case, they renewed the motion. But the judge allowed the punitive damages claim to go to the jury, and we were scheduled to begin the punitive damages phase on the Monday morning following the jury's verdict that Friday afternoon. Now, since Whole Foods was owned by Amazon at the time of our client's termination, we intended to present the publicly available financial information for Amazon and ask the jury to award an amount of money that would serve to punish Amazon for its conduct. And as a result, settlement discussions did ensue throughout the weekend, and thereafter the parties reached a settlement agreement, the terms of which are confidential. Now, I will add that after we defeated the defendant's motion for summary judgment in this case, in the months leading up to trial, defense counsel had initiated settlement discussions and requested that we mediate the case. But among the conditions that we required, and you should most certainly attend the mediations college, where you'll learn all about the use of conditions before proceeding to mediation. But among the conditions that we required in order to proceed to mediation was that the defendant make a 6-figure offer before mediation. Whole Foods never offered 6 figures, so we refused to mediate, and the trial then commenced. So, the EDGE principles just work so well in employment cases. And, I will say that for those who may have just beginning their EDGE journey, just starting out, dabbled, a little bit, took one college here, one college there, I highly recommend immersing yourself in the EDGE system, in the KTI system. Richard and I both had taken a few courses before the pandemic, but really used the pandemic to immerse ourselves completely instead of just toes in the water. And in 2021, after immersing ourselves, we both became graduates and masters in terms of the KTI system. And there's been no looking back ever since. So, and part of the KTI system is just being intentional about everything, and case selection, the claims you bring, just A to Z, everything, being intentional about everything. So the first thing I'm going to talk a little bit about is the importance in finding and presenting the system failure in our cases.
And Patricia, before you do that, let me just add something about what I love about the KTI system. And that is that it is a system. It gives you a method, almost a blueprint for everything that you do, both before trial and at trial. So it's not like you're sitting down a few weeks before trial and thinking, all right, I have to construct an opening here. Where am I going to start? What's an opening look like? Let me talk to, there's a system in place for doing an opening. There's a system in place for doing cross-examination. And so it just makes practicing law, and particularly employment law, I've been doing it a long time, and it makes it so much easier to have that kind of system.
So in terms of the system failures in our Whole Foods case, there were 2 very significant system failures. And that the first one was that Whole Foods, and these related to the rules that we used in the case, the rules that we used in the opening and again in the closing and all throughout the case. But one of the significant system failures in this case is that Whole Foods failed to take the steps needed to comply with the laws prohibiting discrimination. And in order to bring that to life before the jury, we used a checklist and to get a better understanding of the use of checklists, the importance of checklists. Go to the college, go to the opening college, go to the advanced opening college. But checklists are so helpful in terms of presenting to the jury what the defendant did or didn't do that make up the system failure. So in this case, the steps that the basic steps that Whole Foods, didn't take in order to comply with the laws prohibiting discrimination, they didn't train their store managers in the laws against discrimination. So they have up this, great policy, very comprehensive policy that talks about them prohibiting, they can't discriminate against their employees, but they don't train the store managers, store leadership on those policies and on the laws and what they entail. Whole Foods doesn't require its human resources to be involved in the decisions by store managers to terminate employees. So that again was another related, to the basic steps that Whole Foods didn't take. Whole Foods did have their store manager decisions reviewed by an outside consultant, but that outside consultant was not asked to review the termination decision to determine whether there was discrimination at play. All they were asked to do was to make sure the decision tracked their corrective action policy. And so we used a checklist, that brought to life, these basic steps. And it was a very powerful rule, that we, made up a big part of our case in terms of one system failure. The other rule that related to another system failure was the rule that employers have to apply the same performance standards to their employees, regardless of age. And so in our case, one of the reasons that Whole Foods gave for terminating our client was because the presence of out-of-date product discovered in her specialty department, and that she failed to put systems in place. That was actually language in the termination notice, put systems in place to ensure that there was no out-of-date product in her department. But there was evidence in the case that, and so they ended up both disciplining our client and terminating her for the presence of out-of-date product. But there was evidence in the case that there were out-of-date products found in the departments that were managed by the younger team leaders, that they knew about it and that they didn't issue an ounce of discipline to any of the younger team leaders whose departments had out-of-date product. And so that all lent itself very nicely to a checklist, which really made it quite clear to the jury what was going on here. Another very important part of the KTI and EDGE system that is important in any kind of case, but employment cases, definitely applies, is the importance of being a woodpecker during discovery. Like a dog with a bone, like a woodpecker, you don't give up until you get what you need that relates to the system's failures in the case. And so in this particular case, our client was terminated for the presence of out-of-date product. Prior to her termination, she had been subjected to written discipline and then also for the presence of out-of-date product, and ultimately terminated for the presence of out-of-date product. And so in discovery, we asked for, the performance records for the other younger team leaders in the department. And of course, we had a fight about that, but you don't give up. But then, more importantly, and what really kind of cracked the case open in terms of one of the system failures was that there was no discipline in these other, the performance files for out-of-date product for the younger team leaders. But I learned, not from anything they told me, but from kind of independent research, there's a lot you can find out on Google, talk to your client, talk to witnesses. Don't just rely on what you get in discovery. You got to do your own research. But it turned out that there was a third party who came in and did monthly audit reports. And so these monthly audit reports showed that in the months leading up to our client's termination, that out-of-date product was repeatedly found in several of the departments managed by the younger team leaders, and that notwithstanding those findings, no discipline was issued to them. And so, and this, was something I think I really appreciated from the depositions college, which I highly recommend them all, but the depositions college, like, you don't go into a deposition, oh, let's see what I can find out. Again, everything is so intentional. So you go into a deposition knowing exactly what you want out of that witness. But you do a lot of your own research before these depositions, to figure out how you're going to prove your case and to use information that you get even, before the deposition. And so I was aware of this company coming in and doing audit reports. And so when I deposed the decision maker in the case, I laid the foundation for those inspections happening, that laid the foundation for her, getting reports, receiving them, reviewing them, being aware of them, so that when it came time to trying the case and requesting them in discovery, we had all the ammo that we needed. So be a woodpecker, don't give up until you get what you need. Because, anything that is worth getting is not going to be something they turn over willingly.
And I mean, I take from that as well, like read through what you get. I know sometimes we get a lot of information and you're like, oh God, it's the last thing I want to do is read through this stuff. And, but do it and look for those little nuggets. I mean, that is pure magic right there, right? You're like, this is, especially in an employment case, to find disparate treatment so obviously is like the best gift you can get. And so, yeah, request it, keep fighting for it, and then take that extra step and go through it and find those nuggets. You've got to get through it and do it. That's awesome. Thank you, Patricia. All right,
Sure.
Keep going. Sorry, I just wanted to highlight
No, not at all. I'm going to turn it over now to Rich, who's going to talk a little bit about focus groups and the importance of focus groups in our cases.
Okay, just a comment about what Patricia was saying about trying this case and litigating the case as a system failure case. That was one of the first things, certainly, that I learned attending, KTI colleges, that we really want to try these cases. We want to find what's wrong with the system. We don't want to make it into, wow, this was a bad store manager. She was not a nice person and she fired our client, because juries just aren't going to get concerned or upset about that. Juries want to see, whoa, there is a broken system here. And if we as jurors don't do something about that broken system, it's going to happen again and again and again. And that was why it was sort of so important to hammer on the system failure, and not that anybody here was evil or a bad person. And that's how we tried the case. Okay. In terms of focus groups, we have found doing focus groups, and there is a excellent KTI college on how to do focus groups, and there's actually a handbook on how to do various types of focus groups, and we encourage people to do that. But focus groups we found they're so critically important because we as lawyers, we think like lawyers. And we say this to our focus group and why we're doing it. We don't think like real people. We think like lawyers. And so the issues that we maybe think are important in the case aren't going to be important to jurors. And issues that the jurors are saying, wow, that's important, or maybe, not important. It's a totally different perspective. And so without doing focus groups and learning from potential jurors about what they think is important and not important, you're going to rely on what you think is important as a lawyer, and that is not going to work out well. So in this particular case, as Patricia mentioned, they fired our client because they had found expired product in her department. She was at the head of the specialty department. And one of the things that they sell in the specialty department, probably one of the main things, is cheese. And so, we were concerned, like, what's a jury going to think about this? Like, whoa, spoiled cheese, well, maybe they should have fired her. But we did a focus group, and, it was interesting because the people in the focus group were not nearly as concerned about this as we were. They say, well, we shop in supermarkets. You're going to find out-of-date product. It happens. There's no way to avoid, that. And so, that was one of the things that we learned from doing the focus groups, that although we had to deal with the issue, it was not an issue that we thought the jurors were going to go, oh my God, this is terrible. They should have fired her. A second thing we did, Patricia had taken the deposition of this fellow that Whole Foods uses to review their termination decisions. And he's sort of an interesting character. He's from down in Texas, which is where Whole Foods got their start. And this is the guy who they used to review termination decisions. And as it turned out, Patricia asked him at his deposition, well, do you review these decisions for discrimination? Oh, no, I don't do that, So, and it also turned out that it had taken him a total of 26 minutes from the time that he first heard about the termination decision to give his blessing. But we wanted to find out, so we thought that we didn't think this guy was going to play very well in front of a jury. But again, that was our view. We wanted to show people his videotape from the deposition and get a sense of, how jurors were going to view this guy. And so we showed them, we had a focus group and we played the videotape of his deposition at the focus group. And, it was interesting. I mean, they didn't think he was a bad guy. And he didn't come across as a bad guy. Sort of came across a little bit as a good old boy from Texas. But at the same time, they really got it that this was ridiculous that it took, 26 minutes to terminate the career of a 20-year employee. And that was one of the themes that we hit on at the trial that we got, from the focus group. And we actually, in the course of the trial, we had a clock that we showed them that tick, 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 and it went through the 26 minutes, and then boom, a 20-year career destroyed in 26 minutes.
Was that your bumper sticker? Because I feel like that's, I got chills there. 20-year career destroyed in 26 minutes.
That's a really good question. And we thought about that as a bumper sticker, but you know what? We used a focus group to address, whether that was a good bumper sticker or not in terms of sort of summing up the case, or, what getting, and that was not the bumper sticker we used. And it was in part based on the feedback that we got from our focus groups, because we did many focus groups in this case, because the point of focus groups is you can focus group anything. And when you bring, when you get to trial, you shouldn't be guessing about how a jury is going to react to anything in your case, whether it's an exhibit, a demonstrative aid, a witness, bumper sticker, a rule. You could use focus groups to come up with the rules in your case, and you got to go to the focus group college to appreciate and learn about all the different types of focus groups that can be done. But that was not the focus. That was not the bumper sticker we went with. It was when no one minds the store, discrimination will happen for sure.
All right.
And that,
this right here is like a perfect example of how the lawyer brain is not the brain you follow, right?
Right.
And so we talk a lot about collaboration here, and it is so important to collaborate with other lawyers, but never, ever forget to focus group.
Yes. Awesome. Yes. All right. 100%.
Totally. All right, Richard. Sorry about that.
That's all right. Patricia, anything else?
Things get interesting, but
anything else on focus groups, or shall we move on?
Yeah, I think. The other, we use, like I said, you can focus group on anything. I think we also use. We knew we wanted to use a demonstrative aid in terms of an organizational chart, in terms of all the different, people, players, so to speak, and we kind of, struggled with how many different layers, so anyway, we used focus group to, we came up with one thing, showed it to them. It was too confusing. They didn't really like it. So we whittled it down to something else. So, I can't say enough about the importance of focus groups. And we've done them, at every different point in the case, sometimes even at the beginning of the case, before we put the case into suit, we've done a focus group. So can't say enough wonderful things about focus groups.
Okay, switching gears a little bit, I'm going to talk about how we used our trial brief in this case. And, the importance of educating the judge before the action starts at the trial was one of the things that was stressed to us in the various colleges that we've gone to. One of the colleges is a 3-day college called on black letter law. that really gets into the kind of legal issues that you want to bring to the attention of the judge, the importance of doing a trial brief, the importance of getting these issues out there in front of the judge, not in the heat of trial, but ahead of time. And so we prepared a trial brief and we gave it to the judge before the start of the trial. And there were, a couple of the issues that we really wanted to highlight. One of which was whether we have the right to use leading questions when we're cross-examining the defense witnesses. And, that can be the ability to lead them as opposed to having to sort of use open-ended questions is critical. Now, there's a rule that gives, at least in New Jersey, gives the judges some discretion. So we wanted to get that issue out there, and the judge discussed it with all counsel before the trial, and he agreed with us. And so that took one of those issues that we otherwise would have been, scared about, and we would have started to examine the witness, and then all of a sudden we would have gotten an objection from defense counsel, objection leading, and it would have led into a sort of a whole mess during the course of our trial presentation. So it was really important to get that issue out in front of the judge. And then there was an evidence issue that we had to get out there, which was these audit reports that Patricia had talked about that had come in from an outside company. And they were monthly reports, and every month they showed that, hey, there's expired product being found in the produce department. There's expired product being found in the grocery department. But these, potentially these are out-of-court statements that we wanted to get admitted for their truth. And so there was this evidence issue that we briefed to the judge. We had a oral argument on the issue, and ultimately the judge decided that yes, assuming as long as we laid the proper foundation, these audit reports showing that expired product was in a number of the other departments could come in. And again, this was something that I don't think we would have really focused on the importance of a trial brief, having not gone to the Black Letter Law College. There's a whole host of issues that can be introduced in trial briefs and in limine motions. So all this kind of pre-trial work that you do will accomplish a couple of things. You won't be surprising the judge with things that he or she had not anticipated, and it can just take issues off the table that otherwise could be on the table. So that was, it worked out really well.
I'll add, I'm sorry, go ahead, Jenna.
Finish your thought, Patricia, but then I have a couple questions from the audience that I missed, so I apologize. So finish up your thought, and then let's take a couple questions.
Sure. I was going to say, the other good reason for using a trial brief and preparing a trial brief is these employment cases can be very complicated factually. And it's really important to kind of distill the factual essence, for the judge. And so, we spent a lot of time, even in the trial brief, putting together a very distilled, powerful, presentation of the facts, which I think was very helpful to the judge.
And in addition to that, we had a presentation on the law, which was also very helpful because,
right.
One of the key issues in employment cases is whether discrimination has to be the only reason why they fired your client, okay? Or whether it can be among the reasons. And, in New Jersey, we happen to have a very good jury charge which says that no, discrimination does not have to be the only reason or the sole reason why your client gets fired. It can be among a number of different reasons, but as long as that discrimination made a difference, that's sufficient. And that we wanted to make sure that the judge understood that going into trial, and he did, and it worked out well.
Nice. Yeah, that's a great example of strategy to kind of put yourself, you become like a friend of the court, basically. You're your own amici because you become the teacher and the trusted source of information. And then that sets the basis for your objections and how those are going to go and all that kind of stuff. So super powerful. All right. So let me get to a couple. I apologize. I had my chat box open, and for whatever reason, when it's open, it doesn't blink. And so I'm used to, like, if it blinks, I open it up. Anyways, lesson learned. So we have, let's see, contact information for Patricia and Richard will be in the description below. So folks who are looking for that, want to email them with questions or whatnot, that will be there. And then we have a question. Do you ever hire a company to do focus groups? If so, name the company and their contact email, phone number. So let's just answer yes or no, and we can get a name and the rest of it later, but I have a feeling I know the answer. So.
You do know the answer, Jenna. Absolutely not. Because once you go to the KTI Focus Group College and the Advanced Focus Group College, you will do your focus groups better than any consultant. You know your case better and will do them better. And there is so many different types of focus groups that you learn about that you don't need to hire a consultant. You do it yourself.
Mm-hmm. And the beauty of it is that you can do them at a ridiculously low cost. I mean, I think we pay our focus group folks $75 for 2.5 hours at their time. So if you have 6 or 8 people, you're basically doing a focus group that costs $300 or $400. And so you know, if that's all you're spending, you can do 5 or 10 focus groups, and it's not going to be that expensive. Whereas we've never done it, but our sense is that if you brought in a professional to do it, you could probably blow $10,000 on one focus group. So it's really a great thing to be able to learn how to do these focus groups on your own. And we don't see any reason why you need to bring in an outside consultant.
And I will add that I think the pandemic has made it easier to do focus groups, because we used to do them in person, you know, which added to the cost as well. But, you know, Zoom focus groups are very effective, you know, and a lot. You know, I think in some ways you're not limited. You can get people, you know, from further away who can come join your focus group as well. So it really kind of opens up more possibilities. So, yeah.
Yep, absolutely. And we even have the advanced focus groups, which I was supposed to take this summer, but there was some issue. I can't remember what happened. I didn't yet. I've been wanting to for so long, but it's really helps with interpreting what the focus group is telling you. So don't just take the undergrad, but try to get into that graduate one as well, because that one will take you one step further. Did you guys have a chance to do both of them? Because you're masters, I know.
Yeah, but no, we have not. That's one that's on my list as well, to take the advanced one. Yeah.
So, all right, cool. And then finally, Dave Crump just says, black letter law is a must. It is the crescendo of the Edge Symphony. Another one that it's been on my list, and gosh darn it, if it does not get done. I don't know why. The schedule just doesn't work for me. So advanced focus groups and black letter law are on my list of things that I need to get done. But yes, excellent. It's one of my favorite things. I tend to be a very rules-oriented, law-oriented person. Like when I see a case that says something and then the judge makes a different decision, I can't deal with it, because to me, I'm like, that makes no sense. And I'm like, my brain explodes. But if you're able to, you know, explain it clearly, then hopefully you can minimize the amount of times that happens. All right, moving on. Go ahead. I'm going to keep an eye on my chat box here. So we don't.
Sounds good. All right, moving on. Just going to touch a little bit briefly on our virtual jury selection experience, because it was in October. And at that time, we picked a jury virtually, which the judge was in the courtroom, but the jurors were all in their homes. We were in our office, and our adversaries were in their office. And, you know, I have been saying that if I never have to do another in-person jury selection, I would be okay with that, because I thought that virtual jury selection worked extremely well, and that we were able to get a better sense of who the jurors were, you know, from doing it virtually, because we literally were invited into their homes. When jurors are at home in front of their own computer, they let their hair down quite a bit more than they do if they're sitting in court. So I felt like we, you know, learned so much about these people and that we really knew them before we put them on our jury, which is obviously the goal. So it was, and I will say that, well, here in New Jersey, we don't get to attorney conducted voir dire. It's moving in that direction, but the judge conducts the voir dire. But we do now. It is required that the judge each side gets to submit open-ended questions, and the judge has to use open-ended questions offered by each side. So we put a lot of time and thought into our open-ended questions, and this particular judge was wonderful during jury selection, virtual jury selection, because I got a little taste of attorney conducted voir dire, because after he asked questions, he would then, Ms. Barasch, do you have any questions, any follow-up questions? And I got to ask follow-up questions without pre-screening them through the judge. I could just ask them, live, whatever. And so it was very, very helpful. But yeah, it was really the amount of information we got just from looking at them, their home environments, as well as just seeing them in their most comfortable selves was really, really powerful. Anything you want to add about that, Richard?
Because of COVID and other reasons, it'd been a while since we had tried a case in front of a jury. And I suppose it certainly helped that we won in terms of my reaction to the experience, but it was such a wonderful experience to try a case in front of a jury and just to see how the jury system worked. That's what it's intended to do, to bring in, a jury of the plaintiff's peers to listen to the case, to evaluate the case, and to render justice. And we after we picked the jury, it was really Patricia doing the picking. We just loved our jury. We thought we had a really good group of people there who they wanted to be there. That was one of the questions, the open-ended questions, like, why would you make a good juror? And it seems like such a silly question, but it turned out to be a great question. And, these folks they were willing to be there. They were willing to give their time. And it just hit home for me the importance in this country of having a viable jury system. And as though, employment lawyers know, unfortunately, a lot of our cases get forced into arbitration. And it's a shame, because the jury system, when it works, it really is. That's the way justice is supposed to work in this country.
Absolutely. Yeah. All right.
All right. Richard, you want to talk a little bit about just how we put on our witnesses?
Sure. So, of course, one of the questions in these cases is, what order are you going to put your witnesses on at the trial? And, what the KTI system teaches is that you want to put on the defense witnesses first. And there's a reason for that. A lot of reasons for that, I suppose. One of the reasons is we're trying to expose the system failure. And if you're going to try to expose the system failure, the only way to do that is through the defense witnesses. So, in this case, we can call we did call the store manager, as the first witness in the case. And one of the questions we asked her is, well, I think it was a leading question, but, we correct it, you get no training in the laws against discrimination. And we knew what her answer was going to be because she answered the question at her deposition. So boom, yes, it's true. Is it true that, before you make a decision to terminate somebody, you don't involve human resources at all? Yes, true. And, is it true that, when you sent your email down to the fellow down in Texas, it took him 26 minutes to get back to you? True. So we're able, we put the defense witnesses on first because that's how we're going to expose the system failure. The other, I think, main reason that we've been taught in these colleges that we've taken is that you don't want the jury focusing on your client. in terms of, there's this thing called negative attribution. And, when they start to hear from the client, they're going to say, well, maybe I would have done something differently. Maybe maybe I would have, I don't know, any one of 100 things. But you don't want the jury thinking about that. You really want them focusing on the behavior of the corporate representatives, what they didn't do. And so, yeah, we called, before our plaintiff ever hit the stand, we called the store manager. We called 2 assistant store managers. We called the store manager who replaced her. I mean, we had been able to put on pretty much our entire case. And the other thing that we learned in this case about the importance of putting on the defendants first is our client was really nervous about testifying. And one of the things that I think that we know made her nervous was that she was thinking, oh my God, I got to tell my whole story here. I got to explain why, they were picking on me and not picking on the younger store managers, and thinking that she had to sort of almost be her own advocate in that regard. But then, she sat through the first several days of trial, and she saw that we were laying out basically the whole story. We were laying out the fact that they were not disciplining the younger store managers, and they disciplined her. So it just took so much pressure off her. And she told us that, she said, I feel so much better about getting on the stand now because I don't feel like I have to tell my whole story. And that was a real strong takeaway that we got from this trial about why it just makes so much sense to put the defendants on first. Patricia, anything to add there?
I don't think so. It was, the symphony, all of the rules that we had in the case, each of the defense witnesses gave testimony that was relevant to our rules, and so it really did. It laid out our whole case, before our plaintiff took the stand. So it was really, we won our case before our plaintiff took the stand. And that's the goal, to basically win your case through their witnesses. And then it's like icing on the cake.
And how much more powerful is it that the words that you are trying to prove in your case are coming from the defense? We're in a difficult spot as plaintiffs, lawyers of all types, whether it's personal injury or employment or anything else, where we're coming into court asking for money and saying, believe our case. If it all comes from our side, it can be difficult because of, society's views on lawsuits in the past several decades that, we're just coming in here making stuff up in order to bolster our case. So when it comes from that defense witness, and that's like, there's no getting around that. I mean, it's just incredibly powerful.
So that's a good transition, I think, to the next topic we were going to address, and that is witness prep. And it is one of the most powerful parts of the KTI system, in my view, is in terms of preparing our clients for their depositions, preparing our clients both for their depositions and to testify at trial. The college is called witness prep, but then there's also other colleges that relate to this, including damages and direct examination. I highly recommend all three. But witness prep, the whole idea behind the KTI method of preparing our clients to testify a deposition in a trial is to prepare our clients to be forceful advocates for themselves. It's about empowering our clients to identify and embrace their major truths and be the most forceful advocates that they can be for themselves. And I will share with you that it was actually this client's experience at her deposition that led us to immerse ourselves in the edge, shortly before COVID. So this was like fall of 2019. And it really is what led us to, launch our EDGE journey, our KTI, immersion, because as I said, we kind of dabbled before that. But, her deposition, while she, Rich and I have been doing this a long time. So while she testified to all the things that we quote unquote needed her to testify to at her deposition in order to defeat summary judgment, it was a profoundly dissatisfying experience in that she was completely unempowered at her deposition. And we both left her deposition, she and I, that is, feeling beaten up, and after that deposition, I, said to Richard, I never want to feel that way again. I never want to feel that way again. And I have prepared many clients and many witnesses for their depositions since taking, since then, and I have never felt that way again. Never. It works. And, there's, again, there's a process. I will say that, an essential part of the process, and it kind of happens, later on, is a hard cross, where even after you've spent as much time, preparing them, you have somebody else do a hard cross so that, they get a sense of what it will actually be like. But, KTI witness prep methodology is time consuming. There are no shortcuts, but it is essential and it works. And so, we did, she wasn't prepared that way before her deposition. As I said, that's what led us on our journey. But, we did incorporate it into her trial prep. And she was a much more powerful and forceful advocate at trial after having worked with her, to the KTI way to help her develop her major truths. And so she had her major truths when she testified at trial, and she was confident. And so I can't say enough wonderful things about the KTI method in terms of preparing your clients for their deposition and also a trial. And again, it's not just witness prep, but also the damages college, as well as direct exam.
And so you had a situation where you did not use the EDGE techniques, you just didn't know it with deposition, but you were able to use it and have her just feel empowered and knock it out of the park at trial, right?
Yes.
So folks, if you have, don't feel discouraged, like, oh gosh, my client's deposition is already passed. I totally screwed up. I can't can't fix it now. No, you can continue, always go to the colleges, always learn more. You can always, even if worst case, you end up settling. Well, I shouldn't say worst case, just in a situation where you settle and don't go to trial. I mean, spending that time with your client and kind of empowering them as though you were going to trial and continuing to prepare for it is a wonderful part of the journey as well. So, just don't think, oh gosh, this has passed, I can't go to that college, it won't help me. Go to the colleges, find out what will help you, because it will, and you'll be able to use this stuff in other cases or in different parts of your current case. This is a great example of that. Great example.
Yes. No, it's never too late. It's never too late to start your EDGE journey, your KTI immersion. It's never too late. Absolutely.
I think the latest I started one was 2 months before trial, and it was the first EDGE case I ever did. Now, I don't encourage that. Okay, don't think that is something that you want to do. Oh, let's just wait, and you really, it's a fluke that it ended up working for me. But you can take it mid case if you're through some of discovery. If you're a few months from trial, you could implement a couple of different things, maybe take the voir dire course or the opening, something like that. But just do it, basically, not to knock off Nike's little slogan or whatever, but just do it, because it's always helpful. And there's never going to be like the perfect time, right? I don't know, you, Patricia and Richard, it sounds like for you it was no perfect time. There was like a thing that happened and you're like, we cannot put it off any longer. Right. Pretty
much. Yeah. Pretty much that and the horrible deposition experience.
Yeah. Oh, yeah, I hear that. All right. What else?
So, one of the other big takeaways for me from the KTI system, I will never look at an emotional distress damages claim again, the same ever again. Like, emotional distress damages, especially for our employment clients, it's such a huge part of every case, regardless of whether they've, had treatment or not, and in this case, she was a 62-year-old woman who'd never had treatment, before this and, didn't have treatment after that. But, we used her, her husband as the witness who testified as to her emotional distress damages. He was very powerful. The jury definitely liked him, and in terms of the importance of before and after witnesses, both the damages, college, as well as, direct exam, I think touches on it too. But it's so important to develop that testimony, and figure out how to present it, in the most powerful way. I had a case, where I've had several cases since then where the primary claim, there was no economic damages, just emotional distress damages, with results. Before KTI, I probably never would have taken the case, but, not anymore, and several of those kinds of cases settled early on in the case, where my client, or some settled early on, some settled well into litigation, but go to the mediation and go to advanced mediation, because you will learn how to use that testimony in a very powerful way, even for mediations. I did have a case where, it was purely emotional distress damages, and my client, over a Zoom mediation, gave a presentation that was incredibly powerful and compelling. That's a big takeaway for me from KTI, is the importance of emotional distress damages through the use of before and after witnesses, but also how to develop that testimony and present that testimony.
Right.
Yeah, I would just reiterate what Patricia said, that I think it has definitely changed our view on what cases to take. And there's cases that we take now that we never, because, the person was only making $30,000 a year or $40,000 a year. But that is not where the value of these cases is. And I think it really has changed the kind of, the types of cases that we're willing to take.
Yes.
This kind of question actually from the audience sort of fits into this, although instead of talking about the anxiety or emotional distress of the client, each learner would like to know any ideas for dealing with trial anxiety, aside from kind of the practice and prepare shibboleth and that kind of a thing. But what do you guys do?
Trial anxiety for ourselves or our client?
I think that's the question. Please correct me if I'm wrong, but that looks like any ideas for dealing with trial anxiety. I guess you can answer for both.
I'll be happy to answer that. I'll say this. Once you immerse yourself in KTI, you're going to have a lot less trial anxiety, because you have a confidence about your case that is a byproduct, that is a direct byproduct of preparing your cases the KTI way. So I think the KTI system, in and of itself, really helps to minimize trial anxiety. I guess I would even say, like, when I gave the closing in this case, like, I knew we were getting a verdict in our favor. I knew, in terms of looking at the jurors, and have, eye contact with each and every one of them throughout the closing. Like, I knew the verdict was going to be in their favor. I can't say that I before KTI, I ever had that level of certainty in any, case I tried. I mean, I know I didn't. And in terms of the client anxiety, I think, again, that the KTI system, really is designed to empower the clients, to help empower the clients so that they can, it teaches the client how to identify and then, basically repel any attacks that come their way, in terms of at deposition, at trial. It gives the client like the tools that they can be a forceful advocate for themselves, and they can repel any attacks that come their way. So I think that would be my tip for managing trial anxiety for both us as advocates and our clients. Immerse yourself in the KTI process.
Great answer. Do you have anything else, Richard?
Yes. I think Don Keenan, who, is the founder of the KTI process, talks about the importance of preparation. And Mr. Keenan is, he's an incredibly experienced trial lawyer. But he talks about the importance of preparation. And I think, that does a lot to alleviate some of the anxiety. You're always going to be anxious, going into it. But the amount of time that we spend, Patricia and I spend, preparing what I've referred to as a cross-examination of one of these defense witnesses, it's almost obscene, the amount of time that we spend. But we go over these questions, we revise the questions, we know where the answers in the depositions are going to be. We are incredibly well prepared. And because you're so prepared, and because you also have a system that you're implementing and you're not just shooting in the dark, but because you're so well prepared, I think we're better prepared than our adversaries. And that certainly helps to take some of the anxiety out of this preparation. I'm going to add one more thing to that. And that is, I just lost it. I just lost it. Never mind.
I hate when that happens. It'll come back.
It probably will, because it was a really important point. Oh, another big takeaway from immersing ourselves in KTI, and this relates to what Richard just said. Immersing yourself and using the KTI system, it's incredibly time consuming. It is. Like, there's no shortcuts, and it's incredibly time consuming. And as a result, the whole nature of our practice has changed dramatically. Because of how intensive it is, we have less cases in suit at any one time as a result of, immersing ourselves and utilizing, and working up the case, the KTI way. So that was my point. Sorry for that momentary lapse.
Yeah, I would also add that I don't think Richard mentioned this. I think that you're probably not going to ever get rid of it entirely, right? Even Don has talked about the fact that he still gets anxiety because it's just, you're going into something that has a lot of unknowns. What the EDGE system can do for you is eliminate as many unknowns as possible, put you in the best position to not be focusing on things that you can control. And then, when you can't control, you can't control. That is what it is. So, and I would also say that for me anyways, part of it is just doing it. Just forcing, you got to do it. You have to listen. I'm doing this for my client. I'm not doing it for me. I'm anxious, but I've prepared and I'm going in there and I'm doing it. And sometimes it's terrifying. And, I shared last year, I did an episode on how I got kicked in the teeth by a jury, even though I tried my best to do EDGE stuff, it just was there were so many things, but so you're not going to just like overcome it and become this perfect, thing that just is able to go into trial and not be nervous and win every single time. It's always going to be a practice. It's always going to be learning. It's always going to be getting better. And so part of dealing with the anxiety is just knowing it's there and doing it anyways, because that's what you have to do. So
And I would also add just that there's room in the EDGE system to make it your own. And so, it's important not to be somebody you're not, we all can't be Don Keenan, but, to really kind of make it your own and make it work for you. And I think there's plenty of room to do that.
Absolutely. Great questions, everybody. All right. What else you got for us? We're kind of close to the end here. Did you guys have more topics? I did not pull up the outline. So I'm just like enjoying the chat.
Closing argument, right?
Right. Yeah. One last topic, just closing argument, a couple of points there. One takeaway from our experience is just the importance of going over the law and discussing the jury charge, in the closing. We did that right up front. They heard it from the judge. First they heard from us, then they hear from the judge, and it was very effective in terms of what Richard mentioned before, really driving home the point that, age played a role in the decision and that it made an actual difference, not that, it was the only reason, so really focusing on the language of the jury charge in terms of what we have to prove. And then the other thing that we referenced in terms of the jury charge was just reiterating the use of circumstantial evidence, that there's, very rarely direct evidence, but the use of circumstantial evidence, and in particular in our case, the evidence of disparate or comparative treatment of the younger team leaders as a way that we can, prove age discrimination. The other point in terms of closing is just the empowering the jury, really, that's sort of, the KTI system is really all about, you, the jury, the defendants, has refused to accept responsibility. This is on you, and really empowering them, and I think in closing, especially, I asked a lot of questions, which I think was, a powerful way, and a lot of times it came from focus groups, but these are questions you should be asking yourselves, ask yourself this, so that I think that can be a very powerful way of inviting the jury to, empowering the jury. And then, if you have a lie, you definitely want to focus on that. The KTI system, lies and betrayal, form a big part of the KTI system. They're in all of these employment cases, betrayal, hypocrisy, lies. But, in this case, we had during openings, the defense counsel, basically made a statement that was completely contradicted by one of the defendant's witnesses. And we didn't shy away from that in the closing. we made, we front and center because it was, like a critical fact, upon which they based their decision to terminate our clients. So if there's a lie, and it was very effective.
Pointed out.
And at least one of the jurors, and maybe more than one of the jurors, had on their own had figured out the lie. And so when Patricia was going over the lie in the opening and saying, this is what you heard in the opening and this is what you heard from the witness, you could see that one particular juror, she was nodding her head like she had already figured out the lie and she was not happy about the lie.
Mm-hmm. Yep. But jurors do not like that. I mean, they think we're coming in there lying about stuff, but when you turn around and you show that the defense is doing it, very powerful, very powerful. All right. Thank you so much. And I know folks may have specific questions. Feel free to reach out to Patricia and Richard if you want to dialogue with them a little bit more about this case, or if you have questions about EDGE in general. I mean, they're a great example of two people who decided, hey, we don't want to do it the old way anymore. Let's really commit and learn the system. So, I'm sure that they would be happy to share that journey with you if you have specific questions. So thank you all who joined us today for this week's episode of Fridays with Keenan's Cutting Edge. I think it was interesting that we heard almost every single college mentioned today. So I hope that you were able to see how attending colleges gives you real life action items that you can use in your cases right away. If you liked today's episode, please click that thumbs up button and feed the YouTube algorithm. Let them know you find our content interesting. And don't forget to subscribe and sign up for alerts so you don't miss an episode. We're going to have replays the next 2 weeks. I would apologize, but I was supposed to be in trial. So that's why we're going to do replays. My trial got continued at like the 11th and a half hour, but it's very difficult to schedule people when we've already got, some replays lined up. So anyways, you'll be hearing from, I think we're going to do my mom's podcast episode next week on the vestibular stuff. Definitely watch that one. It's great for all of you who have brain injury clients. And then I'm not sure what we're going to have the next week, but stay tuned. You'll get the email. And I will see you guys in a few weeks. And we will reconvene with another live guest. So have a wonderful weekend, everybody. And I will see you next time.